In Chapter 2, we're going to talk about ethics and professional responsibility. The biggest overarching ethical issue with regard to paralegals is the unauthorized practice of law. Unauthorized practice of law is the practice of law by a person who's not authorized, meaning doesn't have a license to practice law in that jurisdiction. So, based on that definition, both attorneys and non-lawyers can engage in the unauthorized practice of law. It's not just individuals who are working as paralegals or in a legal setting. It can be attorneys as well. If I go to Alabama and I don't sit for the Alabama bar, I don't apply to be a member of the Alabama bar, then I am committing the unauthorized practice of law if I begin to give legal advice to people there in Alabama. You want to avoid the unauthorized practice of law. You don't want there to be any doubt that you are not committing UPL. So do not provide legal advice. Don't hold yourself out as an attorney or allow someone to believe that you are an attorney. Do not represent clients. Those are our three big do nots. We're going to talk a little more about what that all means. So there's really no universal definition of what constitutes the practice of law. The definition is flexible. It has no fixed boundaries, and it varies from state to state. So there's a lot of gray area that exists from state to state. There are, there's no clear-cut rules except for some very limited situations. So it can be troublesome to not know when you're crossing into that gray area. Legal ethics rules and criminal statutes help define the practice of law in a jurisdiction. And the highest court in that jurisdiction has the final authority to interpret what the practice of law means. So the courts have, and I will tell you guys over and over throughout the program, that courts love to have a test. They love to have some tangible way to apply the law to a set of facts. So they have created tests to determine whether or not a particular activity constitutes the practice of law. Whether the service performed required the knowledge and skills of an attorney. If it did, that's the practice of law. Whether the service performed was one that's usually rendered by an attorney. Is it usually an attorney who is doing this activity? Whether the service performed was legal in nature or was it incidental to some non-legal transaction? And then finally, whether harm was caused to a third party as a result of the service that was rendered. So those are some guidelines that the courts have applied in previous cases. So as I've told you in the last video, the three things that are pretty much common throughout the country as recognized as the practice of law are providing legal advice, representing someone in court, and accepting someone as a client and setting the fee. Now, there are exceptions to some of those. So, but when you are talking with a client or a potential client, you need to be extremely careful about what information you share. There are going to be things that you're going to learn, that you're going to know based on what you do every day working for an attorney. And many times, the questions that a client has, you may know the answer based on the previous experience that you have. But you have to be very careful not to give that information. Not even simple common sense advice. Don't advise someone of what their legal standing is or what their legal options are. Always just be on the safe side, err on the side of caution, and let that person know that they need to speak to an attorney. So I said one of the widely accepted characteristics of the practice of law is representing clients in court. Okay, only attorneys can represent others in legal matters, but there are two exceptions. One is pro se. You can certainly represent yourself, and there are some federal and state agencies that allow non-lawyers to represent clients in hearings within that agency. So there are some exceptions. For example, the Social Security Administration allows non-lawyers to represent clients in a Social Security. You always want to disclose your status as a paralegal. Hopefully, the first time you meet a client, the attorney is going to make that introduction and make it clear what your role is. But many times attorneys don't. They'll just say, "This is my assistant, Bob. This is Jean. She's going to be working with you," and never really explaining what that person's role is. So always make sure that the client knows that you're a paralegal, that you can't provide legal advice. You can certainly facilitate the delivery, the communication of information between the attorney and the client. You always want to make sure that based on what your firm title for you is, that you add paralegal or legal assistant to any business cards, any nameplates that might be in your office. If they include paralegals on their letterhead, you want to make sure that it states that you are a paralegal. You always want to get that information out to the client in the very beginning. So here is some requirements for what it takes to be an attorney. I include this because many students come to the paralegal studies program. It's their goal to become an attorney, and that's great. I always encourage students to take that route. I've had several students go to law school. I actually had one just pass the bar last week. I've had several just graduate in this past year. But sometimes students coming into the program don't really know what it takes to become a lawyer. What are the requirements? So they can vary from state to state, but usually it is some combination of the following. You have to have a bachelor's degree from an accredited college or university. You have to go to law school, and it has to be accredited by the American Bar Association. You get a doctorate in jurisprudence. You then apply to you take and you pass the state's bar examination, and that's where some things differ from state to state. Some states, you can do that while you're still in school. Some you have to wait. You have to pass a personal background investigation to assure the bar that you have good moral character. You pass a ethics course. Sometimes that could be part of your law school curriculum. Sometimes it might be a separate course. You have to pay your yearly dues. You have to make an oath in court at a swearing-in ceremony, and you have to maintain your continuing legal education hours and pay your dues each year. So in Georgia, when I was in law school, you had the option to apply to sit for the February bar. You would not graduate until May, but you could sit for the bar in February. That changed several years after that. Now you cannot sit for the bar until you have graduated. So your first opportunity in Georgia is in July after you graduate from law school. In Georgia, you have to complete 12 hours of continuing education each year, and those, can tend to be costly. They can run anywhere from $150 to $400 a session. Then you pay your dues, and that can vary based on if you are a member of any of the specialty groups from within the bar. And keep these things in mind because I'm going to talk about it in comparison to the regulation of paralegals when we get to the end. So licenses are issued by each individual state. So if I move to another state, I have to meet the licensing requirements of that new state. That could be that it requires me to take and pass another bar exam. It could be that the state has reciprocity with Georgia, and that I can simply, put my name and pay my dues for that new state. But it varies once again, state to state. So the ethical guidelines for attorneys are the minimal acceptable standards of behavior. Each state has its own rules of responsibility. Most of them are based on the ABA's model rules of professional conduct. Those have changed the name in 1983. It used to be, I believe, the ABA rules for professional responsibility. That changed, they changed the name of it, but most states have some version of that. They may have adapted it a little bit, but it's usually some version of those model rules. And those rules extend to everyone who works for the attorney, specifically or most importantly with regard to confidentiality and conflicts of interest, which we'll discuss in just a moment. The ABA has also issued guidelines about the appropriate utilization of paralegals. You can find that on their website. So if an attorney violates one of these rules, there's some formal sanctions they may be subject to, from the worst being disbarment. Sometimes that disbarment might be conditional, or you may be able to, it may not be for a lifetime. There may be after a certain period of time that you can reapply, or you can retake the bar, and then goes down as far as having to take an ethics class, and everything in between. There's also, those are going to be sanctions that come from, in Georgia, the Supreme Court. There's also civil liability that if it has risen to that level where a client could sue you for legal malpractice, and that can extend to the actions of the paralegal. The attorney is being held responsible for any ethical violations by the paralegal. And then there's some things that, result in criminal liability when an attorney takes money from a client and uses it to pay his gambling debts. So these are the factors that the disciplinary body here in Georgia's Supreme Court is going to take into consideration when they are sanctioning attorneys. The nature of the violation, what was the attorney's mental state, what are the circumstances, is this a pattern behavior or a one-off kind of thing, were there any aggravating, mitigating factors. So these are all things that the court may consider, okay? And keep in mind that lawyers may be disciplined under ethics rules for their wrongful behavior that is separate from their practice of law. Maybe it's something they're doing in their personal life, but there are ethical guidelines where they can be disciplined under them, even though the action had nothing to do with them practicing law. Theft, illegal drug use, DUI. And then also keep in mind attorneys can face other consequences in the legal system beyond the sanctions that might be imposed by that disciplinary body. As I said, civil liability, being sued for malpractice, prosecuted under criminal statutes. So the first specific rule I want to talk about is 1.1, the Model Rule of Professional Conduct 1.1. It is about competence. An attorney, has to be competent in order to accept a client and to accept a case for that client. The minimum competence is knowing the rules of the court, but usually it's going to be much more than that, in that you've got to have some experience working in that area of law, or have the ability to demonstrate that you can conduct that representation as it needs to be done. Meaning, you're not going to be, let's say you are working for an attorney that handles family law, and then all of a sudden, out of the blue, this attorney says, oh, I'm going to handle this merger and acquisition of Coke and this small soft drink company. Well, that's clearly going to be beyond the realm of their experience and their probable capabilities. So that would be a question of whether or not that meets the competence level. The ability to successfully perform a task. The lawyer possesses the legal knowledge, skill, thoroughness, preparation, and reasonably necessary for the client's representation in a matter. How does this get breached? Well, inadequate research. Okay, hint, who does an attorney's research? Usually they're paralegal. Missed deadlines. If the attorney misses deadlines, that's a competency issue. Errors in the documents that get filed, that is a competency issue. And who is drafting those documents? So you see that ethical responsibility is rolling down the hill to you, the paralegal. The next one we're going to talk about is 1.6, which requires confidentiality in client matters. This is a challenging one for lots of different reasons, but the rise in social media and technology makes things more difficult. It makes it more difficult to hold information confidentially. Communications between a client and the attorney, including their staff, are privileged. They can't be shared if the person doesn't become a client. Okay? And there are protections that exist if there's some inadvertent disclosure. But confidentiality actually encompasses two different things. One is this ethical duty of confidentiality, and then there is what's known as the attorney-client privilege, which is an evidentiary principle. And that's something that might be new information for you. People, when they begin to talk about confidentiality and the legal practice, they are focused in their minds on this idea of attorney-client privilege. But actually, attorney-client privilege is a separate, smaller piece of confidentiality. It deals specifically in an evidentiary setting, so we'll talk about that in just a minute. But confidentiality is a cornerstone of the practice of law, because clients need to feel confident that the information they're going to share with their attorney and the attorney's staff is going to be held, with care and concern, and a promise of keeping that information confidential. Okay, there are exceptions. The client can give a waiver, can agree to the disclosure of particular confidential information. That's informed consent. We would want to get a signed document waiver from the client. If the attorney needs to disclose information in order to adequately and successfully represent the client, that is an exception. If it needs to be disclosed, and now most states have combined these next two into one, saying that if the disclosure is required to prevent death, substantial bodily harm, or a substantial financial loss to someone, then the information can be disclosed. If I feel that I need my own legal advice regarding the representation of a particular client, if I go to another attorney asking for advice, then about my legal standing, I can disclose to that attorney. If I have to defend myself in a malpractice claim or a disciplinary action claim that's arising out of the representation of this client, then I have the ability to disclose that information. And if the court requires me, then I have to comply with that court order. What you have to struggle with is conversations that you might be having with a coworker, and you might be overheard, documents that you leave out on your desk, sending communications to the wrong person that discloses particular confidential information. It becomes you have to be careful of what you say, where you say it, and when you say it. And you also have to realize that there will be aspects of your position that you're unable to share with your significant other. Certainly can't share names, possibly can share, the struggles that you face on a daily basis, but not any without any specificity. So attorney-client privilege. Attorney-client privilege arises the minute that a client communicates something to the attorney. It lasts indefinitely. The client can waive it, but it's extremely important during the litigation process because it is an evidentiary principle, meaning that I cannot be compelled to disclose certain information by the court. Anything that's related to the client's legal rights, anything that is deemed the work product, meaning it's something that I have created in my strategy to represent this client. I cannot be forced to turn those documents over. That's work product. So just keep in mind it's two different principles. Confidentiality covers all of it, and attorney-client privilege is a small piece. The attorney-client privilege is a rule of evidence, not an ethical rule. It protects certain communications made between the client and the attorney. The privilege provides that a client who is asking for an attorney's advice or assistance can prevent that attorney from testifying about the communication. The information protected by the attorney-client privilege includes any confidential communications made between the attorney and the client, whether oral or written, concerning the client's legal rights. Now, the problem is, or one of the things that tends to come up, as I said, attorney-client privilege is a narrower concept than confidentiality. Applies to communications made by the client to an attorney while seeking legal advice. But here's the kicker. It only applies to communications made in a confidential setting. So, best example I can give you on that one is, let's say that client is coming to our office because they are going to be seeking a divorce against their spouse, and they bring their best friend with them for moral support as they are talking to the attorney. The fact that that third person, the best friend, is a witness, is there when the client discloses information, that makes the attorney-client privilege null and void. It's no longer a confidential setting. So that's why sometimes attorneys won't let you bring someone in with you because it defeats, invalidates that attorney-client privilege. The next specific rule we're going to talk about is 1.7. It is the conflict of interest ethical guideline, prohibits representation of a client if it would be adverse to representation of a current client or a former client. It applies to attorneys and to our entire legal staff. The legal team needs to be extremely careful when accepting one as a new client. We want to run a conflict check. That could be done simply manually by looking at the files, looking at the names of former clients, to something as sophisticated as a software package that's all it does is conflict check. You put in names and it will tell you if you have a conflict. It's the process of evaluating a prospective client to determine if representation of this prospective client in this matter would create any conflict of interest. We need to do this before we receive any confidential information. We want to detect that conflict before. And there's several different types. One, simultaneous representation, when an attorney represents two clients whose interests are directly adverse. So many times, both husband and wife will come to the attorney and say, we don't want to both get attorneys. We won't pay that much. We know what we want to do. We just need you to draft it so that it's all legal and everything's good and the court will accept it. And that is a conflict of interest situation, because your loyalties would be divided. So it has to be established that one of the spouses is the actual client, and you're going to want that other spouse to sign a waiver. You're going to recommend maybe you need to get your own attorney. You just can't be both of their attorneys. Then there are problems with successive representation, meaning the attorney's representing someone whose interests conflict with the interest of a former client. Maybe I have represented Mr. Smith in all of his business transactions, and I know all about, his tax liabilities, his business, and now he and his wife are getting divorced, and his wife comes to me and wants me to represent her in the divorce. Well, there's a conflict of interest there. I have some knowledge of Mr. Smith and his business interest that if I were not ethical, I could then use while representing the wife in a divorce settlement. But that is a conflict of interest. What becomes challenging is when attorneys move from firm to firm, paralegals move from firm to firm. You're taking with you those clients, so that multiplies the chances of running into a conflict issue. So when a new paralegal comes to work for a new firm, they're going to want to run conflict checks to make sure that there's not going to be too many conflict issues. Now, one or two we can handle. We can put an ethical wall around that paralegal so they don't have access to information about that conflict client. But if it's a large number of conflicts, that's going to make it very difficult. Gifts are a conflict of interest. You want to avoid those. Family relationships, representing someone from your family or working for an attorney who's representing someone from your family makes it very difficult. Another conflict of interest issue is things that have a bearing on the attorney personally. For example, let's say that I have a large amount of Coca-Cola stock. Let's say I inherited it from my grandparents, and I have significant amount. And I work in a complex litigation firm who our new client is going to be PepsiCo. Well, I've got a conflict there because I want my Coca-Cola stock to continue to go up, and now I'm being presented with this opportunity that, if I could do anything to damage the client, PepsiCo. It could make my stock go up. Now, all of this centers around the idea, the hope that attorneys are above that kind of activity, behavior, whatever you want to call it. But even if you are, you want to make sure that you avoid even the appearance of an issue, and that's why we run checks. As I said, the client can waive that conflict of interest issue. I've got some points here that address that waiver. Attorneys need to be forthright and fair. They need to always present their client and the case fairly, present supporting evidence. We want to always turn over the evidence that we are required to under the evidentiary rules, under the discovery rules. We also need to make sure that we address when we're doing our research and then presenting information to the court, we always want to make sure that we are presenting all sides. We can't ignore the things that are bad for our case, bad for our client. And if the opposing counsel doesn't bring up a piece of controlling legal authority that is negative for us, we have to disclose that to the court. We have to be candid with the another requirement for attorneys is that they adequately supervise their staff, specifically you, the paralegal. Attorneys can be sanctioned both by the state bar, by may even rise to the level of criminal sanctions, may rise to the level of civil liability for the actions of their staff. So while paralegals don't have direct ethical rules that are imposed on them, the rules filter down from the attorney and the state bar to the paralegal. As I said, paralegals don't have a specific standard set of ethical guidelines they must follow. If they have joined one of the professional organizations, NALA or NIFPA, have taken a credentialing exam through one of those organizations, they are bound by those guidelines for that organization if they want to maintain their credential through that organization. Some states have some more detailed guidelines from the state regulations regarding the use of paralegals. Georgia does not have any. The only thing that we have addressing paralegals in our statutes, in our code, is the unauthorized practice of law, and that does not even specifically address paralegals. It addresses non-lawyers. So, as I said, paralegals are indirectly regulated through those guidelines that attorneys are subject to. As the paralegals' responsibilities increase, we are seeing paralegals doing so much of what attorneys used to do, but they must be supervised by a licensed attorney. They can't step outside to those three areas that are clearly the practice of law, providing legal advice, representing someone in court, and accepting someone as a client and setting the fee. The last piece of this chapter I want to talk about credentialing licensure for paralegals. Regulation means the process of controlling something by rules or restrictions. So that would mean paralegal regulation means the direct regulation of paralegals by a state through particular licensing requirements and legal ethics rules. So there'd be two parts to regulation. One is the licensing, one is the ethical rule conduct. The regulation of or licensure of paralegals is a subject that has come into focus in the last few years. The issue has gotten some traction, especially in the Northwest. All jurisdictions right now, there's no regulation for paralegals as there are for attorneys. Most states will permit anyone to work as a paralegal, but some states do have voluntary registration regulation, meaning that they are restricting who can use the term paralegal, but as far as licensure, it's not gone that far. As I think I said in the last lecture, that Washington State, Oregon, they have what's known as the Triple LT, the Limited Licensed Legal Technician. That is a licensure for non-lawyers. It's very limited in what areas of law they can practice. Usually it's in family law. And if it's something that actually goes to court, then that Triple LT has to turn it over to an attorney. But it's seen as a way to increase access to justice for people who normally cannot afford legal representation. But it's certainly not a standard across the country. So last I want to look at, what are the pros and cons of paralegal licensure? Who should be in charge of it? Who should be controlling it? Should it be the state? Should it be that state's bar, which are two separate entities? Several of the organizations, who's going to get to have input into the ultimate process for licensure? NIFPA wants, they are pushing for regulation on a state-by-state basis with general licensing and some specialty licensing. NALA wants voluntary certification, or basically self-regulation, and they don't want, they oppose licensing requirements for paralegals. AFBE does not have a position on either one of those. What are some things to be considered? Well, it's going to affect the profits of law firms if paralegals are licensed. Number one, because that means that they're going to require a higher salary. Firms would not be able to, hire and train to their particular firm policies. There would be more of an issue of, what did the state require of the individual. Paralegals would become generalists. They'd have to know much more broad-based knowledge and not have the specialty that many of them have now, that they have accomplished, that they have gained through working in a particular area of law for a period of time. So what are the pros? Licensure ensures that there's some minimal standard of quality in individuals who are presenting themselves as paralegals. Probably the one that is the most compelling to me is that it gives public recognition to paralegals. It elevates you in the eyes of the public, which is a good thing. It raises your professional status and profile of the profession itself. It assures clients, attorneys, that you meet particular qualifications. It protects the public from unethical people who are presenting themselves as paralegals without experience, without education. And it would help to standardize paralegal education across the country. Now, those are the pros. What are the cons? Well, many people would say it's not necessary because the attorney is the one who's licensed. They are supervising the paralegal, and that should be sufficient oversight. It creates, and this is one that these next two are ones that are the reasons why I'm concerned about licensure. One is it creates a barrier to entry to the profession. As I said, as an attorney, if I go to another state, I have to meet their licensure requirements. So it might prevent people from moving freely who are working as paralegals. If they've got to, if their husband or wife, their spouse gets transferred to another state, and now they've got to go try to work in another state that has different licensure requirements, or just the same, but that means more money, which is the next one, increases the cost to the client and to you, the paralegal. You're going to have to, they'll have to have a agency within the government to administer this, which means more money. You're going to have to pay annual fee for your licensure. You're going to have to maintain continuing legal education hours. It's all going to be more money out of your pocket, which will also translate to the legal cost going up, because attorneys are going to try to capture that increase that they're going to have to pay for a licensed paralegal. They're going to pass that along to the client, which then defeats the whole purpose of increasing access to justice. As I said, it restricts the movement of paralegals from state to state. It might also prevent someone from going into the profession because they don't have the money to pay for the licensure or what's required in order to get the licensure. And the last is the flip side of the last pro. Licensure unnecessarily standardizes paralegal education, meaning, many times when something becomes standardized, it lowers the threshold for everyone. So it sets a certain level of requirements for an educational program that may or may not meet what is the expectation or the normal practice of that program.